I'd like to welcome you to Session 2 of Jackson Kelly's webinar, Litigation in the Marcellus and Utica Shale Deposits, a 4-part series on case law in West Virginia, Ohio, and Pennsylvania. Before we get started, I'd like to take a moment to address some administrative issues. To ensure that we limit this presentation to no more than 30 minutes, questions will be answered at the end of the presentation. If you have questions, you may submit them at any time using the chat pane located at the bottom of your screen or send them to marketing@jacksonkelly.com. If you have technical questions during the course of the webinar, again, you may use the chat pane or send an email to marketing@jacksonkelly.com. A web link with the recorded presentation will be sent to you in the next few days along with a voluntary survey. To ensure that there will not be any interference during the webinar, all participants' phones have been muted. Today's webinar will cover oil and gas law updates in Ohio and will be presented by Tom Wilson, an attorney based in our Canton, Ohio office. And with that, I'd like to hand it over to Tom Wilson.
Thank you, Sarah. And again, if anybody is having problems hearing me, send an email to marketing@jacksonkelly.com. I hope everybody is surviving the cold weather here recently that we've had in the east. I'm presenting from beautiful downtown Charleston, West Virginia. And with that, I'm going to get started. We have probably more material than I can cover completely in a half an hour, so I'm going to do my best to hit the highlights, and we're going to have the slides have more information, background information that you can peruse at your leisure once we send out the slides. The first topic, probably not surprisingly, and something that will take up the bulk of our time, is the Ohio's Dormant Minerals Act, codified at 5301-56. There's been quite a few decisions that have come out regarding this act, and when most of the decisions have come out of the trial court level, the Court of Common Pleas, so I'm going to be addressing the courts as opposed to one court. There's been very few appellate court level decisions in Ohio and virtually no decisions at the Supreme Court level. First of all, and again, we obviously don't have time to go through all this information, and we probably have people on the phone that are at different levels of experience with the DMA, but I felt like we should talk about it at least a little bit to give you kind of a basis of what the cases are interpreting and what are some of the key issues. Of course, at its heart, the DMA is used to reunite a severed oil and gas interest with the surface. There's different definitions about what an oil and gas interest can be. It's called a mineral interest in the code, even though it's really just oil and gas because coal is accepted from the DMA. So kind of keep in mind that one of the questions we're going to look at is what is a mineral interest? What can the DMA affect? Also, one of our major problems is that there are two DMAs in Ohio. One was passed March 22nd, 1989, and it was a more straightforward use it or lose it statute in that it did not offer up a process to reunite the surface with the minerals. It basically just happened, or at least that's the way a lot of courts interpret it. That's going to be an issue we need to look at. And then in June 30th, 2006, the new DMA was passed. And then, of course, the statute said nothing about the 1989 Act. It didn't say anything about is the 1989 Act still in effect? Does it replace it? Does it amend it? Do they coexist? So that's another thing the courts have wrestled with significantly. And the DMA, the 2006, is a lot more in-depth. There's a process that basically says you file notice with the mineral owners, and then 20 years previous, you look back and see if there's been a savings event that would prevent the minerals from being considered to be abandoned. And also, one of the most common savings events is a title transaction, which is also not defined in the code or in the statute. So the courts have had to look at that. And also, interestingly enough, in the 89 version of the DMA, they also looked back at the preceding 20 years, as the statute calls it, but they failed to identify where that period begins. They did not say 20 years preceding a certain date or a certain happening. So Yet another thing the courts have had to deal with is when does the 20-year window exist. So hopefully that kind of gives you an idea of some of the issues that the DMA has raised. Again, the Ohio Supreme Court has not ruled on it. Very few appellate courts have ruled on it. And so we're left with the many counties, however many counties are in the Utica production zone, the 20 to 25 counties that are each coming up with their own rulings on their own and oftentimes conflicting with each other. One of the advantages that we have, and I'm going to move quickly through some of the DMA's background that you can look at later if you'd like, but one of the advantages, of course, we have, or maybe it's a disadvantage, is that the Utica, really the production's only started in the past couple years or so, so therefore all the cases I'm going to talk about today probably at the oldest are 9 to 10 months old. Of course, the DMA, the newer version wasn't passed till 2006, but we've had the 89 version for the past, what is that now, 20-some years, 25 years almost. But of course, a lot of claimants weren't going to court over a traditional vertical well that may just been producing a little bit of gas and oil, but people are much more likely to go to court over a Utica well that's producing a lot of money. So one of our first questions, I'll move ahead here, is simply which statute applies. You know, we have the 1989 Act DMA that was passed, and then the 2006 DMA, and of course the 2006 did not say anything about how it interacts with the 1989, even though it replaced it completely. And your first thought may be that, well, the 1989 Act is dead, I cannot use that, but actually a large majority of the courts, and again, these are trial court decisions mostly, if not completely, but the majority of the courts have decided that the 1989 version does stand, that it can coexist with the 2006 DMA, and that also any rights that were vested under the 1989 DMA will stand and are not retroactively taken away or undone by the 2006 Act. And for example, Went v. Dickerson looked into that issue and held that under Revised Code 1.58 that the 2006 DMA does not have the express language required to retroactively undo what the 1989 Act has done. Also, while we're on the topic, and these cases tend to address a multitude of issues, of course, they're not just on one point, so I'm going to have a little bit of back and forth here on the issues, but also with Went v. Dickerson, it was also interesting that they did use both the 89 and the 2006 analysis. They said basically the plaintiffs, the surface owners, could win their case under either one of these acts. They quickly did away with the 2006 DMA because the plaintiffs did not follow the statutorily required notice and filing of affidavits and all that. So they had made no attempt to do that. So they were left with the 89 Act, and they interpreted that and actually held in favor of the plaintiffs. The defendants tried to claim that a warranty reservation was sufficient as a title transaction, and hopefully I'm not too deep in the woods here, but in other words, the defendants, the owners of the oil and gas, said that there was a savings event, that their oil and gas was not abandoned because deeds would contain language, for example, I convey you 20 acres, but accepting and reserving the oil and gas that was previously reserved in 1952. And the courts pretty uniformly held that this is not a title transaction, that you actually need an actual conveyance or reservation of the oil and gas in that deed and not just a reference to a prior reservation. So again, the plaintiffs won their case there. And Also, interestingly enough, and we'll get into this more in a moment, is that while the court originally referenced the passage date of the 1989 DMA, they did not use that as the date for the window for the 20 years preceding. They actually used March 22nd, 1992, and then looked back, clear back to March 22nd, 1972. And the reason they used 1992 is that the 89 Act gave a 3-year grace period in which, they passed it in 1989, and then they said, you have 3 years, well, oil and gas owners, you have 3 years to enact some sort of savings event, whether it's oil and gas production, a title transaction, or whatnot. And then after that, after these 3 years, then the surface owner is free to file and try to claim your minerals under a theory of abandonment. So this court said, well, we're looking back 20 years from when that grace period expired in 1992. Again, majority of trial courts have considered the 1989 DMA to be in full effect and will usually analyze a plaintiff's claim under both to see if they can win. They don't have to win under both. They can win under one or the other, and if they do, then they get the minerals. Of course, we have an exception. Very recently, just over a month ago, was the Dahlgren case in Carroll County, which is especially interesting since I believe Carroll County has more Utica permits and wells than any other county, and was the birthplace of the Utica exploration. But anyway, in Dahlgren was very much an outlier in that they looked at the 1989 DMA as fundamentally flawed because keep in mind there's no notice provisions, there's no due process, there's nothing. It just allows the minerals to automatically be reunited according to most courts and based on a simple reading of the statute. Dahlgren came along and said, well, actually the 2006 DMA was intended to fix the lack of notice provisions in the 1989 DMA, and the 1989 DMA is fundamentally flawed, and at best the 1989 DMA vests an inchoate right that would need to be vested either preferably by a judicial procedure that meets constitutional due process requirements, and at the very least a recording of a affidavit of abandonment. And if you really think about the two DMAs, it does seem like the legislature did exactly that. They had the 89 version that was very bare bones, and then they came along and redid it with a bunch of procedures. So even though Dahlgren is very much an outlier according to the other trial courts, it does make sense that the Dahlgren's conclusion is correct that the 89 DMA was kind of flawed in that it did not provide proper notice procedures. So we have the 89 one and being interpreted by Dahlgren as basically not automatic, and then the court did look at the 2006 to see if they could meet the requirements that way. And again, like I said, these issues tend to run together between the cases, but again, just like Dahlgren at least touched upon, but not directly, is the 1989 version constitutional because it does not have any process. It does not, at least on its face, it has no due process, no procedure that needs to be followed. That's not been ruled upon by the Ohio Supreme Court. Several trial courts have expressly found, especially Tribbitt v. Shepard, have found that the 89 DMA is constitutional. In Tribbitt, they mentioned the Texaco v. Short case, which is a U.S. Supreme Court case in 1982 that upheld the constitutionality of Indiana's Dormant Mineral Act, which is very similar to the 89 version of the Ohio statute. In Texaco v. Short, they really based their decision in large part on the grace period. Indiana had a 2-year grace period. Ohio had a 3-year grace period. So it does stand to reason that the 89 DMA is safe from a constitutional claim at the federal level. Of course, state like Ohio can provide for additional protections beyond the federal baseline. So it is at least possible that a court could find the 89 DMA unconstitutional under the state of Ohio's constitution. But even Dahlgren didn't go quite that far, even though it did dance around the issue. And Tribbett v. Shepard has expressly gone the other way, that the 89 DMA is constitutional. Again, we have some different viewpoints. No would be, you have to look at shall have no power to pass retroactive laws. We have some case law there. Again, this also, as much as anything, goes to the fact that whether or not the 2006 DMA can overturn or upset what's already been accomplished by the 1989 version. Again, a little more information on the U.S. Supreme Court decision, and also just to keep in mind that there's been neighboring states and other oil and gas producing states that have not been afraid to declare their DMAs unconstitutional. Although there's at least no indication right now in Ohio that that's going to happen for the Ohio DMA. Again, the Ohio DMA, one of the big issues that they've had to look at is when does this 20-year process begin? Like we said, the 1989 DMA just says the preceding 20 years. It does not say preceding what. So we have 3 conclusions that I think we've already talked about a little bit, but one is March 22nd, 1989, when the 1989 DMA became effective. This was supported by an appellate court decision in Ohio. Again, nothing at the Supreme Court level. So this is one theory. Second theory, and there's some additional cases which use the 1989. Note that they are all trial court of common pleas decisions, so you have to be careful about trying to give those any kind of broad application. And also, please note they're all very recent, so one's in 2010, but the rest are in 2013, so it's obviously a part of the law that's still being figured out. Okay, number 2, the second option is a fixed look back from March 22nd, 1992, when the grace period ended, so that you would look at those 20 years to try to find a savings event, which can include a title transaction that would prevent the oil and gas from being considered to be abandoned. But if you could, let's say you could find a 20-year block of time before because once the 2006 DMA kicks in, we're done with 1989. Obviously, in 1989, the courts have allowed it to exist from 89 to 2006, but once the new one is there, you have to follow its rules. But let's say you can find a block of time, for example, there's no savings event from 1969 to 1989. Or even maybe even better actually would be 1999 from 1979 to 1999. Well, that's what Shannon v. Householder looked at, and they eventually concluded that there were no savings events, but they did entertain the idea that a 20-year period could have existed from 1999 to 1979, and basically they looked at it as a rolling period that. So the end of your 20 years could be any time from 1989 to 2006, and then look 20 years forward. In some ways, this kind of makes sense to me, just kind of thinking about it logically, the Shannon v. Householder decision. But I can tell you that it is a minority position amongst the trial courts, and there's no guidance at with the Ohio Code, revised code, to let you know whether or not Householder got it right or the other 2 options are right. Yet another issue that has not been decided, and we have courts coming down on both sides. Again, like we talked about in the 20 years, you can have a savings event, and a title transaction is one of them. A title transaction is not defined in the DMA. There's really not a lot of guidance, but one thing that has to involve is a mineral interest, and one of the things, I'm going to skip ahead a little bit here to get to my next point. Again, this is good background information if you're interested. Does an oil and gas lease title, or is an oil and gas lease a title transaction? That, again, you might think that's a simple question, but not for the courts in Ohio. Bender v. Morgan has held that it's a conveyance of a defeasible fee or a determinable fee interest, and basically that it is a title transaction. It conveys an interest in real estate, and so that a recorded oil and gas lease would save you from abandonment. Actually, Shannon v. Householder, which again is an outlier, but they said nope, an oil and gas lease without production is not a savings event. Of course, production in and of itself could save you, but that a lease that was not drilled and producing, nope, sorry, that's not a savings event. It's not a title transaction. So these courts are coming down on both sides, even on questions that are in theory pretty straightforward. Okay. Also, we've talked about references to severed mineral interest is not a title transaction. Dodd v. Krosky is actually one of the rare appellate court decisions. The trial court held that it was a savings event title transaction, and appellate court said no. And again, this is just a reference to a previous reservation of oil and gas that you see in deeds, and not the actual reservation. The actual reservation would be a title transaction, as set forth in Walker, I think Walker v. Noon, and also Dodd and Krosky. Moving on, the Marketable Title Act is still out there. It's a 40-year look back, but at least in the past year, the cases have not dug into that. I've included some information for your perusal, but I'm not going to talk about that today just because the courts aren't talking about it in the past year. Only other thing left on DMA, which, like I said, was going to use up most of our time, and I think it has, but is a mineral interest. Well, the DMA applies to mineral interest. Is a non-participating royalty interest a mineral interest that can be reunited with the surface and oil and gas through DMA? And this is NPRI is a royalty interest where there's no right to lease the oil and gas. There's no actual ownership of the physical oil and gas in the ground. It's a simple right to receive a portion of the value of the oil and gas that's produced. Well, the Supreme Court in 1927, Supreme Court of Ohio, basically said a royalty is personal property, and again gave the definition I just gave you. Well, that didn't stop a Monroe County Court of Common Pleas court, and if there are any judges on the phone today, I apologize, but and I see their distinction. They held that the NPRI is realty and was able to be reunited with the surface and oil and gas, their dormant mineral filing, and they held that that it is realty when it's in the ground. And you'll notice the Ohio Supreme Court case references once it's been produced, and it'll be up to an appellate court. Actually, they did appeal this, and it was settled without a decision coming out of it. But eventually, it'll be up to, hopefully, the Ohio Supreme Court to give us some guidance. I know a lot of legal experts think that the DMA should not apply to NPRIs. Okay, we got a few minutes left. I'm going to talk about the Beck Energy case, as it's commonly known. This is a case dealing with whether municipalities, such as cities or townships, can regulate oil and gas to any extent. Of course, the ODNR is the main regulator per Ohio law. They issue permits, they regulate exploration and production. And Beck Energy got a permit to drill within the city of Monroe Falls in Summit County, Ohio, and they proceeded to undertake that, and then the city came to them and said, well, there's several ordinances that prevent you from doing this, and we don't care that you have a proper drilling permit from the state of Ohio. You need to stop. And so the city sued for an injunction under several of its ordinances and was granted the injunction by the trial court. But then the appellate court came in and went the other way on most of the ordinances. The appellate court basically held that the ODNR completely regulates oil and gas in Ohio, and that any of the zoning statutes or other ordinances that the city of Monroe Falls has that violate or prevent the usage of the drilling permit are void. And I don't think I've got enough time to read all the statutes to you here, but they're mentioned in the materials. But basically, there is an exception. The ODNR's power, they do allow local authorities to regulate things dealing with care, supervision, or control, public roads, and permits for oversized vehicles. So while Beck Energy certainly won their case, the appellate court did hold that the ordinances from the city that dealt with the public roads were valid and could stand up to the home rule analysis, but that the remaining statutes, including zoning and other ones that required Beck Energy to put up money for a city bond and whatnot, were all considered void, and that basically the ODNR completely regulates that area, and therefore the city cannot pass, the municipality cannot pass laws regulating the production, search for, et cetera, exploration for oil and gas. And this one, of course, has been a pretty closely watched case with briefs filed on both sides. And in June of this year, the Ohio Supreme Court agreed to hear the case. So we are looking at a decision coming down. I think Pennsylvania's looked at something similar very recently. My guess, and I guess we'll talk about this more when we do our roundtable, my guess is the Ohio Supreme Court's going to agree with the appellate court and give effect to the ODNR over top of the city's ordinances. And again, this is not necessarily litigation, but just to wrap this up, please be aware that there is a frac tax being posted, or I'm sorry, being considered, and that it's going to be 1% on the first 5 years of production. I don't have the number in front of me, but I think I want to say that they thought it might produce $1.7 billion in the next 10 years. Of course, that money would be used to beef up the ODNR's regulators and to expand their operations to handle all this extra production. Previous version of the tax talked about reducing the state income tax, but I don't think that's going to happen with this one. This is a tax just on shale drilling, and it's been supported by the Ohio Oil and Gas Association. Seems to have industry support. The governor of Ohio had proposed another tax that was higher, but he backed off that after he did not get support for that, and now we have this one coming out of the House of Representatives that, like I said, is going to be 1%. So definitely something to keep an eye on. And that wraps up our presentation. Again, sorry I had to run through it so quickly, just a lot of information. Feel free to contact me I'm sure you have my information, or it's going to be on the slides. You can feel free to call me or email me with any kind of questions or thoughts you have, or if you've found an interesting case, by all means speak up. With the Court of Common Pleas, it's sometimes hard to track down these cases or to know they're out there. I don't think we have any questions, so thank you all for participating. We hope you'll join us again in the future when we do Pennsylvania and then the roundtable. To exit the webinar, simply click the exit button. Thank you.